So, Asha, is Jack Smith going to be able to introduce all the evidence he needs to convict Donald Trump?
Eh, it's complicated. I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet. So I would say that this latest unsealed filing by Jack Smith can definitely not be boiled down into a soundbite or a tweet. Even though there have been a lot of sound bites in terms of like some of the, I guess, shocking revelations of some of the things that he knows that Trump said or did.
Yeah, I have to say, Asha, it was one of the longer legal filings that I've gone through in my career, and that's saying something because I've been practicing law for over 20 years. I was going through it. I'm in the middle of my jury trial, and in between, I'm reading parts of this filing, and wow, it is very extensive with all sorts of arguments and all sorts of evidence.
Yeah, and I think he received special permission to file something this long. He actually had to ask the court, but I think it makes sense, and frankly, I think it's a very elegantly and elegantly written brief that is also, in my opinion, very accessible to a lay reader. And I would encourage anyone who's listening to this to really to go online and find it and read at least the facts portion, because what struck me is in some ways taking out the whole DOJ subplot, which that was the piece of the conspiracy where Trump was asking his acting attorney general Jeffrey Clark to send false letters to states, to Georgia, saying that there was, to falsely claim that there was election fraud. The Supreme Court ruled that that was official. Those were official acts. Those were absolutely immune. Do not pass go. Do not collect $200. So that's out. And even though that was a part of this bigger scheme, I think the way that these facts are written out now have a certain like momentum, like they keep building to the conclusion in a very straightforward way. And he lays it out kind of starting from well before the election in terms of seeding the idea that the election was going to be rigged, to how the litigation was instituted as a way to try to challenge these things, and then how the fake elector scheme was concocted, and basically how all of these fake elector conspiracies were formed, which I think is really the basis now of his indictment, right? Because that is, the easiest one to argue is outside of any kind of immunity, and we can talk about that. And then leading into the days going into January 6th, where there's these conversations happening with Pence, which creates a little bit more of a trickier story. But I just feel like it's more linear. The way that it now reads, you totally see the case. I mean, I could just imagine him presenting this case, I guess, in front of a jury.
Well, that's clearly what this is. It's almost like a roadmap to what his case would look like. And that's what a prosecutor should be able to do. By the way, it's always an issue if the prosecutor doesn't know how they're going to put on their case. It's clear that Jack Smith and his team put just an insane number of hours putting all of this together, not just in the brief, but all the work that led up to this. I also agree with you, Asha, that sometimes for a prosecutor, cutting out extraneous subplots can make a case stronger. Whether you think of it as a subplot or a side quest or what, in this case, there may be a less is more element to it. One thing was struck by though when I was reading the factual background is how much the January 6th committee and their work provided a Cliff Notes version of a lot of this. And I felt like, oh yeah, I already know a lot of this story. And I think we don't really appreciate, or people have underappreciated how important that committee's work was in terms of informing the public regarding what was happening.
I completely agree. So much of this, I could remember the testimony that was being given to the January 6th hearing, for example, with Hirschman, the I guess the counsel that was the liaison between the White House and the campaign. You know, he features a lot in this filing. I would say it's the opposite, though. I think this brief is the cliff notes of the January 6th hearings,
Mhm.
because I think the January 6th hearings, they were so in depth and provided so much detail, so many witnesses, that the that narrative structure, I mean, you knew what everything related to, but this one I think just smooths it out into like a very clear story. Um, Much more so than I think the January 6th committee report, which I think is also recommended reading, essential reading, but I think harder to digest just because it's so voluminous.
Yeah, I think that like trial lawyers are professional storytellers. That's
Yeah.
what we do. I often explain to my clients that it's like putting on a play, essentially, and I got various characters and so on. I don't think maybe the committee, a bunch of politicians and their staff were that was their bread and butter of what they did. But it's very important because I think, people were wondering what this filing would mean and what it's like, how it would matter. And I'm not an expert on how this will impact voters, but I really think that this would be quite an October surprise if it was all a surprise. But I think part of what happened was that the January 6th committee really already informed the public of so much of this that it's really baked into our understanding of what happened at the twilight of the Trump administration.
That's true. Though I do think that, but for the Supreme Court's decision, I mean, unless this had managed to go to trial by now, some of these details would not be laid out in this way at this time, except that the Supreme Court threw it back to the district court to figure all of this out. And so Jack Smith is doing kind of what you said that prosecutors don't normally do, which is sort of lay a lot of the cards out on the table of what he intends to prove, the evidence that he wants to show, because these immunity determinations have to be made in advance. So he knows exactly what's on the table. And I think part of the reason this is complicated is that it really depends on what is left of the evidence once the not only Judge Chutkan rules on what has immunity and what doesn't, but it goes all the way to the Supreme Court, which it will, and they determine. Just to review, I think the Supreme Court's decision on the absolute immunity question, if you'll recall, the court basically came up with three big buckets. There are acts that go to the core of Article 2 executive branch functions, and those are absolutely immune from prosecution. This is why the Jeffrey Clark conversations, which was the president talking to his, acting attorney general, are off the table. Then there are official acts that are entitled to that, including official acts in the outer perimeter of the executive branch's official duties, that are entitled to presumptive immunity, which means that they're presumptively immune unless the government can rebut the presumption by showing that charging this conduct or using it as evidence in a prosecution would not create an unduly chilling effect on executive branch functions. Like, will allowing this to be charged or to be used as evidence in the future cause future presidents to be like, oh my God, I cannot talk to that person, or I cannot engage in these kinds of activities because I might be prosecuted. So the government has to rebut that presumption by showing that that's not going to happen. And then there's a third basket of things that are not official acts that are not immune, and it's just fair game, and you can knock yourself out and I guess charge away. And basically, what Jack Smith's argument here is that he's first taking the in the legal argument, he's arguing that the Pence conversations between Trump and Pence, which the court said were presumptively immune, they already made that determination. The question is whether Jack Smith can rebut it. He tries to rebut it by saying these were not conversations that were happening in their official capacity. They were happening in private capacity, as running mates, as electioneering, campaigning. So we can talk about that. And then he basically is just like, go big or go home. He says everything else here is not official conduct. All of these subplots, all of this fake elector shenanigans are not official acts. So he's really going very aggressively that almost none of this should be affected by the court's determination.
Right. And I like that's true to form for Jack Smith. He's been very aggressive in this case. But I will say, he does offer in the alternative, right, that this could also potentially just, even if it's an official act, it could be rebutted for the reasons you just said. And one thing that really struck me, I will say, when I was reading through this, Asha, I had not focused as much on that element of the Supreme Court's decision. I mean, one thing I will say is just from the beginning, I think you and I discussed at the time that the Supreme Court's decision to have these evidentiary determinations where you can't even use some of these things as evidence, I think both of us thought that was very unusual, very questionable, and it sure left a lot up to courts to decide. But I think now that I really saw it all laid out, I'm like, wow. I mean, there's really not much to the idea that this was official. I think it's fairly obvious that Trump was acting in his capacity as a candidate, to put it in I think that's how Jack Smith described it. But also, it's just amazing how much here is left to appellate courts effectively to decide. In other words, I think the Supreme Court understood in the way they teed this up that this is going to end up back in their court, and potentially Trump would be long out of politics or whatever, far down the road by the time this actually got to trial as a result.
Yeah. I think what Jack Smith does in this filing to substantiate his argument that this is all non-official conduct, this was all Trump acting as candidate Trump in his private capacity, is number one, he focuses on the deceit, the evidence that he knew this was false. This was all a concocted, idea that the election was rigged. And this to me is important because it's necessary to counter what will be Trump's argument, which is, as the president, I have an Article 2 authority to take care that the laws be faithfully executed. And among the laws that I have to faithfully execute are election integrity laws. And, even if those are administered by the state, I have, I don't know how what he would argue, but that there is some, that he needs to make sure that the slates of electors that reach, Congress are valid or something like that. But the point is, he's going to try to make the argument that he had a legitimate good faith belief that there was fraud in all of these places, that he had a duty as president, not just as a candidate, to address those things. And so all of these conversations that he's having with these state officials, et cetera, are in service of that. And what Jack Smith does on that point is he has so much evidence where he's pointing out, for example, the fact that Trump knew this was false and that he and his attorneys were throwing out like contradictory numbers about the number of dead people who voted. Like every day the number would change, for example. Or when he would contact state officials, they were always Republican officials, and they were always only in states that he had lost by a narrow margin, not in any other state. And also, a lot of statements by his private lawyers that they knew these claims were bogus. And I mean, to me, it was really compelling. And I think that is a really strong counter argument to this, take care clause argument that I think Trump is going to make.
Yeah, I mean, I think just thinking of this as a trial lawyer, I think that the weight behind the Trump argument there would really come from him saying, "I relied on my attorneys, and people like Rudy Giuliani were telling me, and Sidney Powell and so on, were telling me that there was actual fraud and that they had evidence of it, and I believe them, and maybe I was wrong to credit them. Maybe I should have credited these other people, but Rudy Giuliani used to be the United States Attorney in the Southern District of New York, and he is a mayor and a fabulous figure. And Sidney Powell used to be a federal prosecutor, and I trusted these people, and they told me this, and so I had to get to the bottom of it." And one thing I think that Smith does and this is a similar move that was made by the January 6th committee, is really set up a credibility contest there and show that Giuliani was being regarded not just by the attorneys, but by the non-attorneys as some sort of loon who would say anything. And I really think you mentioned Hirschman a moment ago. To me, he's the most important witness
Yeah,
along
he's super
those
important.
lines. Yeah, I mean, to me, it's interesting. One thing I always find fascinating, Asha, is these kind of bit characters in American history. I always thought to myself, oh, if I had the opportunity to do the right thing and make a difference or something. And I think for Hirschman, here's a man who was, I think, a friend of Kushner's and Ivanka or something, was in this position where he was kind of a go-between between the White House and the campaign. And he's like a low BS level person who just kind of calls it like he sees it. And he was just like telling Trump, giving him blunt advice. I appreciate it. I'm like that way with my clients. Like, it's just, there's no way Giuliani's wrong. It's never going to go anywhere. This is a waste. You're wasting your time. He's never going to get anything. And that's really, really important evidence to demonstrate that Trump was being told by his own lawyer that there was nothing to what Giuliani was asserting, and Powell and others.
Right. And I think that also what was happening even before the election is really important here too. I mean, the fact that they were already seeding this narrative about the election being rigged as early as July of 2020. And here they have the Smith's team has a lot of evidence that this was a strategy going in, that they totally understood that because of the large number of mail-in votes, that Trump may look like he has a lead, and then that lead would start getting eroded as the votes got counted, and that it was a strategy planned ahead of time to declare victory very early on and then claim that it was robbed from them. So I think that also, unless they're have some, seeing into the future powers, that I think undercuts that this was actually a good faith reaction as the commander in chief and president of the United States to, real allegations of electoral fraud. What I thought was really interesting was the way that the attempts to pressure all of these states and then to engage in litigation in all of these states on false pretenses with false claims, which, I guess some of these people have been sanctioned or disbarred because of it, but it's kind of astonishing how much they knew that they were just filing frivolous and false lawsuits. And then finally the enlisting of these fake electors, and really how much subterfuge and deception was going on even at that level, because the Giuliani and his team were telling even the fake electors that they were conscripting, we're asking you to do this just to have a backup in case we win some of this litigation. And some of them actually bought that. And so it's interesting that not all of the fake electors were necessarily in on it. Some of them were duped, and but then there were others who weren't. And then to go to your point about people in history, that some of these people just refused to go along. Like, they're like, no, like, this is not by the book. These were electors who would ordinarily have been the ones, if Trump had won, putting together his electoral or voting on his state, the state's electoral votes for him. So they're Republicans, but some of them were like, no, this is weird and we can't do this way. And Giuliani and his team were like freaking out because they're trying to find like people to take their place and do it in the dead of night, when nobody's looking, kind of thing.
Yeah, and it really reminds me of, like, let's say in Watergate, right, where it's like we have a counsel who's fired because he was defying Nixon, or back in the civil rights movement, there's certain people who are heroes, and I think there are a lot of heroes here to the story, whether it's Michael Ludig or it's officials like Brad Raffensperger or others, and people who are lesser known or played a smaller role in the story. But I think it's so important here because, and you kind of alluded to this, Asha, when you talked about disbarment proceedings and other things and criminal proceedings, is that a lot of what happened here is you had attorneys abusing their role as an attorney. I mean, in other words, using their role as an attorney essentially to provide cover for
Yeah.
Trump to do something very corrupt. I mean, in other words, he wanted to prevent the peaceful transfer of power. Bannon and others concocted this scheme kind of in the beginning, is the way I think Smith lays that out. And these attorneys provided cover and made it much harder to convict Trump. I mean, this would be a lot easier case if you didn't have the attorneys involved, because then it's just Trump off doing stuff. But this main defense he has of like, hey, the attorneys are telling me this was true. The attorneys are telling me to do this. That it makes it harder. And it's really because these attorneys abused their authority to basically operationalize what Trump wanted them to do. Trump needed somebody to say he won, needed somebody to say there was massive fraud with no evidence, needed somebody to sort of spearhead these state-by-state efforts, and he found some willing people in the case of Rudy Giuliani and Sidney Powell and others.
And I think it goes even further. I think they not only provided legal cover, they abused the legal system itself, because the lawsuits were there to create a smokescreen of, this veneer of, oh, these things are still contested. One, to dupe these fake electors to get on board, like that there was some legitimate basis to need a backup, but also to overall kind of add fuel to this disinformation operation, right? So these were frivolous legal lawsuits that were being filed just to like create, and again, the Jeffrey Clark thing was a part of that too. It was, let's send these letters so there's like official, in scholarly terms, this would be called legitimizing propaganda. So you're creating other forms of propaganda that corroborate what your main narrative is, and they're doing this, and these are the lawyers that are doing this. And so, yeah, I agree with you that that's astonishing, though there is quite enough evidence that Trump also knew that this was bonkers. I mean, in the way that he was, for example, talking about Sidney Powell. Everybody knew that her claims were crazy. And so, including Trump, like, I don't think there is, I suppose though, his claim that he was relying on his lawyers really goes to the intent portion of whether he committed the crime, not so much to the immunity piece, I think.
Correct. I just think that's going to be the fault line in the trial. Okay. You don't need, I'm not giving, before there's all these comments, like I'm giving away some secret strategy. I think this is obvious to anyone who's tried a lot of criminal cases. Like that is the through line. That is going to be the defense. The defense is he was surrounded by lawyers, and they're going to be the Chesboroughs or Cheeseborough, and Sidney Powell's and Giuliani's of the world who are telling him whatever. And so they have credentials that are, like I said, I recited some of them. Cheeseborough, Harvard Law School grad. These people are all got these credentials.
Eastman was the dean of Chapman Law School.
Right. And so all these people were telling Trump whatever, and they presumably are going to say they really believed it at the time.
Yeah.
And that provides cover for Trump. So absolutely, that'll be the fault line of the trial. And it's really why Jack Smith has to work so hard. I mean, I think if they weren't involved, this filing would have been a lot shorter, don't you?
Yeah. But yeah, I do, but I think he also has them dead to rights in terms of, I mean, he has Eastman basically saying, yeah, this is completely illegal. He basically is advising against filing a lawsuit about whether Pence can, send back electoral slates, because he's like, no, that's totally illegal. And if we actually file the lawsuit, then a court's going to say that. And so we don't want that. We want it to be ambiguous. And so he's clearly engaging in bad lawyering, so an illegal and criminal lawyering. However, I will point out to our listeners, he is Justice Thomas's former law clerk. In case you didn't know that. So, I suspect that there may be at least one sympathetic ear on the court. But yeah, I think overall, look, I don't know what to say about this court, but I think you would have at least 4 votes on the court already that this whole fake elector scheme is not official conduct, because the Supreme Court's opinion, even Amy Coney Barrett was like, she says so. She's like, I don't think any of this stuff is, any of this fake elector stuff would fall into the official conduct. Where the trickier part comes is when Mike Pence gets involved. I think that's, to me, where it gets really tricky. And I think it's also where, if some or all of that is taken off the table, it seems like it significantly weakens his case. Because recall that if it's at all covered by immunity, it's not only that the actual act can't be criminalized or charged, you can't even bring it in as evidence of motive or intent for anything else.
Yeah, I agree. And that was, I would say, the most questionable part of the court's ruling. I think a part that Justice Barrett was not really on board with. But bottom line is, it means that there's a lot of shades of gray here in terms of how this is going to come out for Jack Smith. I mean, he put forth a massive filing. It takes a long time to read, much less digest. You have to imagine Judge Chutkan's going to take some time to digest that and really carefully consider all the points that are raised here, all the different evidentiary issues, because it's not just an episode by episode thing. It could be act by act within each episode, right? We're talking about like Mike Pence, but that's like a whole series of different things that Trump did, or conversations and so forth. And then that's going to go up in appeal, as you indicated earlier, Asha. So, and then you could have some sort of split decision on all sorts of very specific factual issues. And then that's going to come down, and there may be disagreements about that. Well, the Supreme Court said you couldn't introduce this evidence, but what about this document or this conversation that's related to that? There could be a whole lot of stuff there. So I really feel that this is set up for a very long and complicated road ahead.
Yeah. The Pence conversations are critical in my reading to actually set up the charge for conspiracy against rights. Because that's the piece. So the conspiracy against rights charge, this is that Trump basically used threats or force or intimidation to prevent the right of people to have their vote counted, which indirectly would have happened if Pence had not basically certified the election. But that is the charge that really gets to the violence that occurred that day, right? He didn't charge incitement to insurrection. So that's the one that gets to why he incited the mob. And so all of these conversations, what Jack Smith intends to do is to talk about not only that Trump kept pressuring Pence, but that Pence kept saying no, and was like, no, guess what? I can't do that. No, I can't do that. I cannot do that. I cannot do that. And he keeps saying that. And every time that he's refusing, Trump is getting more and more incensed, and he's getting more and more desperate. And so this whole come to the ellipse, it'll be, it'll be wild tweet that he puts out is really the preparation for deploying the muscle, because he knows that that Pence is reluctant or refusing to go along with this on his own. So if you took that pressuring out, I think you don't have the motive for why he's encouraging all these followers to show up on January 6th, why he's telling lies to his followers leading up, building their hopes up that Mike Pence is going to do the right thing. Mike Pence has told me that he's on board. And then you don't have the full context for what he says in his speech at the ellipse, and then for the tweet that he does once the mob attacks, where he says, Mike Pence didn't have the courage. All of those things have to be presented against this backdrop of Mike Pence refusing to succumb to Trump's pressure. So it would just be, I don't know how you would have that charge without those conversations.
Well, I also think I agree with everything you said. And I also think that the whole Mike Pence piece has so many tendrils that come off of it that are very helpful. A lot of Mike Pence's staffers and lawyers and so forth were actually provided a wonderful counterweight to what, or a counter example of what Trump was and his team were saying and doing. And there was some back and forth there that is very helpful as well, challenging Eastman and so on. And so I just, I think that loss also hurts sort of the main through line, right, of what Smith is trying to do, which is to try to suggest that Eastman and all them couldn't be relied on, because there's some of the best conversations are really there, between some of Pence's staff and lawyers and those the corrupt lawyers that were trying to enable Trump. And so, I think that's going to be an open question. I think it's the most likely stuff to be excised by Supreme Court.
Yeah, and I think on that point, he makes a good legal argument. I mean, he really brings a constitutional argument that, that the vice president's role as president of the Senate in order to certify the Electoral College literally not only doesn't have anything to do with the president's official duties, but that if you look at the framers' intent, the entire point was to exclude the president from anything having to do with that, precisely because there's a conflict of interest with the president and who wins the election. That you don't want there to be any power for the president in that process, because it would create adverse incentives. And, I think this just all goes back to the two biggest fears of the framers of the Constitution were foreign influence and self-dealing, right? And so this is a self-dealing issue. Like if there were some Article 2 authority either over the states and how they conducted their elections, or over the Congress certifying the election, that would kind of be bad idea genes for us. I mean, it just doesn't make any sense in terms of the structure of the government.
Yeah, it's important for our listeners to recall or to know that at the time that the Constitution was created, the framers did not conceive of anything like political parties. They did not believe that the vice president and the president were going to be joined at the hip as some sort of that you'd select your VP candidate as some lackey who's going to go around and praise you and try to get people to elect you. The thought process actually was that each state would put forward its most honored individual, and the person with the most votes to be president, and the person with the second most votes to be vice president, waiting in the wings. They'd be rivals of sorts, sort of like how Washington and Adams, or Adams and Jefferson and so forth were.
Yeah, exactly. I was going to say, the vice president was basically the runner-up.
Right. So that would be
in America. Yeah. If for any reason the president can no longer fulfill his duties, it goes to the runner-up, and they have nothing to do necessarily with each other in terms of their political agendas.
Right, it'd be like Hillary Clinton would be the vice president or something like that, and she would be doing whatever she's doing with the Senate, but you would never conceive of the idea that the president would be influencing her. She'd have her own agenda.
And conversely, for the same reason, you don't want the vice president, when he's in this role, to have anything other than a ministerial function. Because for the same reason, there could be adverse incentives to do shenanigans because, if they were the incumbent vice president, they lost.
Right, or throughout the, maybe they want, maybe they want to get rid of a rival or something along those lines. So, yeah, no, I mean, there was definitely a lot of safeguards built into the constitutional framework we have to prevent a single individual from screwing things up, and having the vice president be president of the Senate in a very narrow role was part of that.
Yeah, so I think Jack Smith has a really good kind of structural constitutional argument for why this kind of interaction between the president and vice president, when it comes to the vice president's role for this particular thing. I mean, there may be other times when the vice president is acting as president of the Senate and has to cast a tie-breaking vote where the president might have some influence because it's about legislation that they have some interest in jointly as an administration. But he's pointing out that this is a very different context. And then he adds on to that, and by the by, they were both talking about the election. Like they had a joint they were jointly united, as you just pointed out, in their interest of the election. That's what this was about their campaign. So they were speaking as running mates, as it was part of the electioneering, is what he's claiming. And I personally feel like that's a really strong rebuttal to the presumption that this is in the outer perimeters, but I don't know.
Yeah. I mean, the thing is, the Supreme Court kind of had a chance to consider that. It's not like they were totally unaware of what had happened, okay, when they were considering this the first time. And they seem to not want this to be part of the story in the indictment. And so, realistically, Jack Smith is trying to push the issue. And as you said, I think earlier, should be aggressive. But that seems to me like one of the first places where Judge Chutkan may cut this down or narrow his proof a little bit.
Yeah, I hope she doesn't. I hope she lets the Supreme Court take the responsibility of doing that, if that's what they want to do. The last part that I thought was really interesting is the Jack Smith's treatment of Trump's tweets and the speech at the ellipse, which he wants to introduce in its entirety. I mean, he's basically saying all of these tweets that I want to introduce are all Trump acting as candidate Trump. It's electioneering. It was all about his false claims. And here's an important detail that I think was very clever. So he says all of these tweets. And so first, I mean, the tweets include, let's see, election related claims or challenges, about how there's all this voter fraud, tweets that are attacking officials for refuting election fraud. So these are different secretaries of state. This is Chris Krebs, the head of CISA. Tweets to his followers for January 6th to show up in DC, be wild, all that stuff. The tweets about Mike Pence before January 6th. This is where he's lying and saying that Pence is on board and I hope he did the right thing and he knows that he can do this and play the Pence card. And then the tweets about Pence on January 6th, and specifically the tweet he sent at 2:24 p.m. where he says Mike Pence didn't have the courage. And he tweets that as he's sitting alone in his dining room watching the mob attack the Capitol. So he knows that they have gone wild. And what I thought was really interesting is that Jack Smith says all of these were sent from the real Donald Trump Twitter account. Now, Trump, as president, also had the @POTUS Twitter account. That's the official Twitter account for the presidency. None of these subjects were tweeted out from the official Twitter account. They were only tweeted out from real Donald Trump account. And I thought that that was just like a really brilliant distinction of, if he was like somehow tweet, if these were all matters of, that concerned his duties as president, they would have been coming out of this other account, because the POTUS account often retweeted the real Donald Trump account. And he says the only tweets that the POTUS account retweeted on that day were ones later that afternoon that were encouraging these people to disperse peacefully.
So, yes, and look, it's an important distinction for Smith to draw, because the Supreme Court, I think, suggested that the tweets may be, in fact, official statements. I think one challenge for Smith is that Donald Trump says all sorts of things out of that account, or at least he did at the time. And some of them, I think even some courts have found, were official statements, because he would make all sorts of like official whatever thought, I'm going to fire this person, or I'm going to do this, or I'm pardoning this person, or whatever he was doing out of that account. But that, you can bet your bottom dollar that that's going to be a big fault line, not only in front of Judge Chutkan and in the courts of appeal and so on, but then if it does come in at trial, like that'll be a big fight about, like he's just saying, his personal opinion and so on. Because even if the courts go the other way, you can imagine, or Judge Chutkan does, and that piece of it doesn't go up to the Supreme Court, you can imagine his lawyers trying to set the stage or say, Jack Smith tried to make it seem official, but now that we see more of the facts, it's really not, or whatever.
So, two things that struck me as interesting. One is, well, maybe this is a question. If his tweets and like his video where he tells all the rioters to go home and peacefully, and let's say that he was and Jack Smith concedes, he's like, he did that in his capacity as president, and that was an official act. We don't intend to introduce that as trial. So like Jack Smith has no intention of introducing any evidence of Trump ultimately telling people to leave. And that's a big part of Trump's narrative, right? I mean, even now he says, I told them to be peaceful, and he keeps latching onto that. So if Trump introduces, like, if something is immunized, does that mean like nobody can bring it in? Like it can never be touched? Or I'm assuming that as a defense, the defendant could bring it in. However, if he brings it in, is it sort of like an opening the door kind of thing? Then he can be.
Well, it's complicated. So here's what I'd say, a couple of things. So first of all, it's a very clever, sort of like a lawyer's trick kind of move that he's playing on Trump here.
Yep.
Because Trump cannot introduce his own statements, because they're hearsay at trial. So it would be interesting. He
can't introduce his own statements,
right? So
unless he testifies, is that right?
Right, he could do it through his own testimony, but he could not introduce an out-of-court statement that he made. Now, Smith can, because Trump is his opponent. And under the federal rules of evidence, and non-opponents, out-of-court statements are not hearsay. Yeah, not hearsay. But of course, Trump is not his own opponent. So technically speaking, one thing the prosecution does, it's like drives us. I'm in the middle of a jury trial now, and the prosecution does this to me, where it's like, hey, your client said this, but we're not going to let you introduce it because that's your client. It's a hearsay statement. So I think that's part of what he's doing. He's putting Trump and his team in a bit of a trick bag, where they have to effectively, they want to get the story in, they have to do what you just said and waive the official part of it. And then if that occurs, they say it's official, maybe they could try to get it in, or at the very least put Smith in a spot where now he's going to put it into evidence. But then there's a leakage, right? When you waive a right, and it's the same thing when, like, for example, someone waives attorney-client privilege, that often the waiver goes further than you'd like. It's hard to draw a circle around it, because once you start waiving, like, where does that stop? And so I think that's a clever move by Jack Smith.
Well, it is, right? Because either, like, Smith he obviously doesn't want to or need to put in that Trump went in front of a camera and told people to disperse and leave peacefully. That doesn't affirmatively help his case. But if Trump wanted to put that in and decided to testify about it or whatever, then all of the circumstances that led to that, which was that it came 4 hours after the attack on the Capitol or whatever, or that he had to be forced to do it, that he initially refused to do it, that he kept wanting to not say certain things, that, they took, whatever, 10 takes. I don't remember all the details, but in other words, he was more or less coerced into doing that. And I would assume that Jack Smith would then have at least the latitude to elicit all of those details, which
Well,
then it's sort of like reverse Uno on Trump.
yeah, it definitely is a situation where he's going to be there. I don't know if I'd say coerced, but pressured, right? He was certainly pressured into it, and he had a lot of advisors pushing him to do it, and all of that. So I would assume that would come in, and that would be, it would be it's a clever, like I said, it's a clever move. It puts Trump and his team in a position where they have to decide: do you want that entire story out? But if you get it in, it's a mixed bag, and those are the
Yeah.
sorts of decisions made at trial all the time.
Yeah. And then there, in a similar vein, I thought it was interesting that in this filing, Smith says, when he's describing the tweets that Trump is sending out while the mob is attacking. So he basically says he launches this mob to the Capitol. Then he came back. He went into the dining room. He's alone. He's watching Fox News and he's on Twitter. And he says, we don't intend to introduce his conversations with his staff during this time at trial because those would be official acts. However, for the purposes of determining whether the tweets he was sending out at this time constituted official acts or not, we're going to give you the context of what was going on in those few hours. And they talk about how, his staff members came in and they were like, Mike Pence is in danger. And he's like, so what? Who cares? And, there's another like exchange that he has. And it's just really interesting because yes, these aren't going to get in front of a jury. And he says that he won't put it in front of a jury, but he's gotten it out into the public now.
For sure.
And he conceded they're official acts. He's using them for evidence to determine the legal question of immunity, even if he's not allowed to and does not intend to introduce it as evidence of any criminal activity at the trial itself.
Right.
And I think
it's interesting. I mean, it's the first time, obviously, this has ever happened because this is the first time anyone's ever had to deal with presidential immunity and this new decision by the Supreme Court. But it's akin to other times in the federal rules of evidence, for example, when you have to make a determination about whether there's a conspiracy or other things. You can draw in all sorts of evidence, and the judge can consider that, even if it hasn't been admitted yet into evidence, or maybe some of it may be inadmissible, but the judge has to make a finding for evidentiary purposes. And really, that's effectively what Chutkan's doing here, is saying, for evidentiary purposes, I'm determining that these tweets are not official, and I'm looking at all these circumstances as to why.
Yeah. And I think he has a good basis to do it because that 2:24 p.m. tweet, I think, is the linchpin for Trump's intention, and that he wanted that mob to go after Mike Pence. The 2:24 tweet where he says, he didn't have the courage. So that is going to be really crucial. It's going to be really interesting to see whether that crucial tweet makes it in, and then what the Supreme Court says about it. But to get to the bigger question of how he's, presented all of this, we talked a little bit. There was some back and forth among legal commentators before all of this, that there was going to, after the Supreme Court's opinion, that there would be a mini trial. And this isn't quite a mini trial, but it is putting out a lot of stuff that, even if it's not surprising, it's still putting out a lot of stuff into the public arena. One of our legal commentator colleagues has characterized this as a cheap shot by Jack Smith, and that he has ignored all of the Justice Department's admonitions against doing things close to Election Day, and this is all about tanking Trump and his electoral processes. And I I'm just curious what you think, because I, I think that's untrue.
It's interesting, but this is part of what happened. I'm in the middle of a jury trial against the Justice Department, so I don't even know who you're referring to. I could guess,
Uh-huh.
uh, but I probably a good guess of who that is. I guess my reaction to it is, I think this was done pursuant to a court order, right? Judge Chutkan ordered him to do it, and he also released a redacted version pursuant to a court order by the judge. And the action and the law and the indictment was done long before the election, and the timing of this is really due to the Supreme Court's decision. I mean, I
That's
think
what
that's
I
what Jack
said.
Smith would say if he was the bearded person on the podcast instead of me. And I think that's right. I think it's just very difficult to claim otherwise in the circumstances. Essentially, what I this mystery commentator is suggesting is that Jack Smith had an obligation to get an extension of time past the election or something along those lines, and I think that's a bridge too far.
I agree. So, Renato, before we go, every October, really every September and sometimes even August, depending on how early it starts, there's a big public debate about pumpkin spice.
There
A,
is?
yeah, like A, whether you like it, and B, how early it's appropriate to begin the pumpkin spiciness.
Wow. Well, I will just say to you that I'm not a big fan of pumpkin spice. I'm not a big fan of pumpkin. It's just never been my favorite. I'm not a pumpkin pie person. I prefer like apple or blueberry or something else, something fruitier, less savory. And I've never liked pumpkin spice latte or any of that stuff. I don't know about you.
I like the smell of pumpkin spice.
Okay.
And I think spice is good in theory. It's got those warm, you know, spices. I do like that. And I like that it, to me, when it's at the right time of year, I think October is fine. It's a nice signal that we're changing seasons and the holidays are approaching, and I like that. I like the olfactory um sense, that gives you that signal that we're changing. But I do get that it's kind of overdone because it's now in everything. Like, it's in Cheerios and it's in coffee and yogurt and everything.
It's capitalism for you. Anytime anything becomes a hit, it ends up saturating the marketplace
Well, we'll talk more about Halloween and what we're doing in a few weeks.
for sure.